ir slēgtas. Un nākamais darba kārtības punkts padomes un komisijas paziņojuma Eiropas Savienības un ASV datu privātuma regulējuma sniegtās aizsardzības pietiekamība. And I would like to start to giving the floor to Council on behalf of Council to Minister ROSWALL. The floor is yours.
President, honourable members, Commissioner, as we navigate the digital age, we must ensure that personal data is collected, processed and transferred in a responsible and secure manner. At the same time, we cannot underestimate the importance of transatlantic data flow in driving innovation, collaboration and economic growth. By striking the right balance between privacy and free flow of data, we can unlock the full potential of the digital economy while safeguarding individual rights and freedom. Today's debate certainly reflects the importance of transatlantic data flows. There needs to be clear rules that ensure that the digital development improves rather than hamper the transatlantic cooperation. This is not only important for our economies, but also for the trust in our digital environment and for protection of personal data. The European Parliament has stressed that the ability to transfer personal data across borders could be a key driver of innovation, productivity and economic competitiveness, as long as there are adequate safeguards. The Council shares this view and considers that adequate decisions are an essential tool for companies to transfer personal data safely to third countries. It is for the benefit of both companies and individuals that these decisions comply with all the criteria set under the GDPR and the Court of Justice case law. The Commission's draft adequacy decision should also be considered in the light of our common objectives with the United States to ensure safe, secure and trusted cross-border data flows that protects consumers and enhance privacy protections, while enabling transatlantic trade. Both sides have committed to keep working together to strengthen the legal certainty when it comes to transatlantic flows of personal data. We clearly need to pay special attention to US agencies' access to data and the need to guarantee access for Europeans to an independent and impartial redress mechanism. The United States' commitment on these two elements should inform our discussion on the subject, and I encourage the dialogue the Libe Committee will have next week in the US. I would also like to stress that Member States will play their role in scrutinizing this draft decision during the comitology procedure. As we celebrate the 5th anniversary of the GDPR effective application, we have a timely opportunity to demonstrate and ensure its ability to facilitate the free flow of personal data within the Union and the transfer to third countries, while ensuring a high level of protection of personal data. Thank you very much for your attention. I look forward to the debate.
Thank you very much, Minister, and would like to give a floor for the Commission to Commissioner Reynders. The floor is yours.
Thank you, President, dear Minister, honorable members. I'm grateful for this opportunity to debate with you today before the vote of an important resolution of the European Parliament concerning the EU-US data privacy framework. I very much appreciate the particular vigilance of the Parliament in this file, considering your essential role in the preservation of fundamental rights, such as the right to privacy. During my intervention, I would like to underline some important elements of the new contemplated framework. First of all, I would like to draw your attention to the fact that this new framework is very different compared to the previous one, the EU-US Privacy Shield. In the meantime, the European Court of Justice has clarified the requirements to be fulfilled in order for the European Union to adopt an adequacy decision. As you know, the Court of Justice invalidated the Privacy Shield on 16 July 2020, concluding in its Schrems II ruling that the safeguards were insufficient on the US side in the field of national security. This ruling was a strong reaffirmation of the fundamental right to data protection under EU law. The Court confirmed that the protection must travel with the data and that the level of this protection must be adequate to EU standards. The requirements of the Court guided me in the negotiations with my US counterparts, the Secretary of Commerce, Gina Raimondo, and the US Attorney General, Merrick Garland. I can assure you that this ruling has really been my mandate. Let me recall that the Privacy Shield was invalidated by the Court for two reasons. First, insufficient safeguards in terms of necessity and proportionality as regards access to personal data by US intelligence agencies. And second, insufficient safeguards in terms of individual redress in this area. It is on these two key points that, on behalf of the Commission, I have negotiated with the US, and I consider that we have obtained very significant changes to the US legal framework to address these two issues. The US have indeed changed the rules governing the operations of their intelligence agencies, which had not been the case under previous frameworks. This should not be underestimated in an area as sensitive for any country as national security. Our draft adequacy decision is built on these new US rules, and I'm pleased that the European Data Protection Board has also recognized and welcomed significant improvements. Another important element is that the solutions found are similar to those accepted by our highest courts in Europe when striking the delicate balance between, on the one hand, privacy and, on the other hand, important public policy objectives such as the protection of national security. Indeed, these solutions are based on the legal standards applied to EU members by the European Court of Human Rights, the EU Court of Justice, and national constitutional courts. This is notably true for the necessity and proportionality requirements, which are, for the first time, clearly spelled out in details in the US legal order. The US authorities will be obliged to balance different factors, the same as those required by the case law of the EU Court of Justice, such as the nature of the data, the seriousness of the threat, or the likely impact on the rights of individuals. Let me now say a few words on the new redress mechanism. The Data Protection Review Court is an essential element of the new framework. It will be composed of independent judges. Let me underline straight away that, contrary to some allegations, these judges could not be dismissed by the executive. The European Data Protection Board has notably highlighted that the new framework puts in place an independent and impartial court that will take binding and enforceable decisions on complaints lodged by Europeans. This court will adopt fully resonant decisions after having heard a special advocate. This special advocate will have as exclusive mission to represent the interests of the individual and will need to be a member of the bar. Therefore, it will be subject to exactly the same ethical and professional obligations as any lawyer in the US, notably in terms of independence. It is true that the information contained in the initial response given to the individual at the end of the process will be limited, but it will still clearly state that if a violation was found, it has been remedied. And the concerned individual will have access to the full resonant decision when this will no longer pose a risk to national security. These limitations are part of the balance to be found between the adversarial process and the protection of information relating to national security. This has been fully accepted by the European Court of Human Rights when accompanied by safeguards similar to the ones negotiated with the US. Finally, the functioning of this redress mechanism, including due process aspects and compliance with the decisions of the new court, will be overseen by an independent body specifically responsible for data protection, the Privacy and Civil Liberties Oversight Boards. Monsieur le Président, Mesdames et Messieurs les députés, nous travaillons actuellement pour répondre aux observations formulées dans l'avis du Comité européen de la protection des données. Et nous examinerons aussi attentivement la résolution qui sera adoptée par votre Parlement. Je peux déjà vous dire qu'en réponse à l'avis du Comité européen de la protection des données, nous sommes prêts à fournir des explications supplémentaires, à clarifier davantage certains aspects du nouveau cadre et à renforcer le suivi concernant plusieurs éléments. Parallèlement, nous travaillons en étroite collaboration avec les États-Unis à la mise en œuvre du nouveau cadre. Il va de soi que les éléments de mise en œuvre doivent être pleinement en place pour que notre décision d'adéquation puisse entrer en vigueur. Pour conclure, je souhaiterais souligner que ce nouveau cadre a pour but d'assurer la continuité de la protection pour les citoyens et la sécurité juridique pour les entreprises. Je me suis engagé personnellement dans ces négociations avec les États-Unis et j'estime que nous avons obtenu des avancées significatives qui répondent aux exigences de la jurisprudence de la Cour européenne de justice et permettent dès lors de conclure en faveur d'une équivalence entre la protection offerte aux États-Unis et le cadre juridique de l'Union. J'espère pouvoir compter sur votre soutien pour reconnaître ces améliorations importantes que nous avons obtenues par le biais de nouvelles règles juridiques contraignantes aux États-Unis. Des progrès importants qui ont notamment déjà été reconnus par le Comité européen de la protection des données. Bien entendu, soyez assurés que la Commission sera particulièrement vigilante pour assurer la mise en œuvre de ce nouveau cadre juridique